We are live.
All right, welcome back to the House Judiciary Committee this Friday afternoon before town meeting break, February 7th. We had an introduction to H772 before we broke for lunch, and now we're going to move to a walkthrough with Cameron. So if you could join us, Cameron, and just by way of a further introduction before you get started. So our work on this bill is a drive-by of the areas that are within our jurisdiction, essentially our lane. I know that folks are going to want to discuss lots of other things in the bill, but since we have very limited time, I want to make sure that we're trying to stick to our lane, which essentially is court process, the impacts on the court of this, and any kind of due process concerns if we identify due process or constitutional concerns. I don't think there are the latter, but certainly want to look at due process, court process, and we will look at that. So there are going to be sections that Cameron will kind of give us an overview, but I think you'll note the areas that are really our focus, and I will remind people, and that also goes with testimony of witnesses. Really want to focus on those areas because whether we agree in this committee with this bill one way or another, that's not really our focus at this point. If we have other issues with this bill, we can take it up with the House General Committee that did pass it out 8-3 yesterday. But we're going to really try to stick to our lane because they've spent several weeks trying to find compromises, as I think Representative Bartell mentioned. So with that, I will Bartley, sorry. No, that's Representative Bartley. Cameron, over to you. Welcome to the committee.
Yes, sir.
Nice to have you here.
Ditto. It's nice to be here. For the record, Cameron Wood, Office of Legislative Counsel. I think this is my first time being in this committee and in this capacity. I've been with the office now. This is my second year in this capacity, but I clerked for Leg Counsel around 10 years ago. And at one point I interned under the esteemed Michelle Childs. So,
Okay.
Yeah, so I'm very fortunate.
You'll probably cut that piece out of the video and send it to her.
Send it to you guys can cut it out and send it. For those who don't know, I cover many areas, including consumer protection, bankruptcy, retirements, and pensions, but I also cover one of the primary areas of my portfolio is housing. And so that's why landlord tenant, you get the pleasure of dealing with me. So I'm happy to walk through the proposal of amendment from the House General Committee. And if it's okay with everyone, I'll share my screen and then we'll start to walk through. This is a 33-page draft amendment, and it has quite a lot of changes to the residential rental agreement chapter in Title IX. This is the chapter that governs, most of your kind of standard landlord-tenant relations, if you will. I'm going to highlight a few things. As Mr. Chair, you mentioned, I won't go through every single section, but there are a few things here that I need to highlight and walk through with you because it really does set the basis for when we get to the ejectment chapter and dealing with the judicial system when you actually need to eject someone from a dwelling unit. So for starters, just understand that there's kind of a two-step process when you're talking about removing an individual tenant from a dwelling unit. For starters, the landlord has to terminate the residential rental agreement. That is the first step. And there is a section that I will have to walk through in detail with you all. It talks about the timeframes and how a landlord goes about, and for what reasons a landlord can terminate a rental agreement. From there, if an individual tenant remains in the dwelling unit after the termination date of the rental agreement, the landlord then has to bring the ejectment action in court to go through that process before you could get to a final judgment that the sheriff would deliver. And then ultimately, if the person continues to stay after that point, remove the individual from the property. So I just want to highlight, there's kind of two really key pieces to hone in on throughout this whole process. The termination and what you're terminating for, and if you're complying with the notice requirements. And then separate from that, if the individual remains at that point after the termination, having to bring that into court. So I'm going to start with page 1. So section 1, this entire section is amending the chapter related to residential rental agreements. But the first piece to hone in on is the definition of actual notice. This is key because when you're providing that termination notice to the tenant, you have to do it by providing, quote, actual notice. And that's defined here as meaning receipt of the written notice. The first two key pieces there, it has to be in writing, and the individual tenant has to actually receive it. Currently, the statute says written, either hand delivered or mailed. Those are the two options. And what this amendment will do is add additional options to how actual notice can be provided. Starting with the sub 2, can be delivered by sheriff's service. And I would say I don't think there's anything right now prohibiting that from occurring. So this is just adding in something that, could already be done by hand deliver. It doesn't say it has to be hand delivered by the landlord. So adding delivered by sheriff's service, and then you have in the sub 3, mailed to the last known address or the address provided in the residential rental agreement. 4 would be emailed to an email address included in the lease agreement and mailed as described in subdivision 3. So if you're going to email it, you also then need to mail it. Moving to the top of page 2, if the last known address is, if the last address is unknown, then posted on the door of the dwelling unit. So you would only be able to do the quote, kind of tack order, if you will, if you didn't have the last address of the individual. And then here we get in the sub B, there is a rebuttable presumption that the notice was received, and you can see the amendment here is extending that from 3 to 5 days after adding the date the email was sent, if sent via electronic means, the date the notice was posted to the door, or if the sending party proves that the notice was sent first class or certified, the date of the mailing. So again, currently it's hand deliver or mail. You get a presumption if you mail it first class or certified that the person gets it 3 days later. It's a rebuttable presumption. And so because they're adding in the capacity to email it or post it, they're adding those into the rebuttable presumption as well, but they are extending that out to 5 days instead of 3.
So was there any discussion or looking at whether, particularly with respect to the posting and the 5 days and such, whether that was reasonably calculated to effectuate service? This is one spot that makes me a little bit nervous, if that's considered actual notice.
So there was a lot of discussion about, the mailing service and current delays with the mailing delivery. There was discussion about if you're going to have email, some individuals don't, always read the email when it comes in. How do you know that they received it? So there was a lot of discussion about that. And I think the committee wanted to extend it out to 5 days with some of that under consideration. But, the committee didn't have discussion as far as when I was in the chair about having a separate notice period or a separate rebuttable presumption period if it was posted on the door.
I guess, and the other related question is whether this follows Rule 4 of the Civil Rules of Civil Procedure. This tracks that or not.
I haven't done, kind of an exhaustive review of Rule 4. What you'll see later on in the bill is there is some kind of changes to when alternate service of process is ordered in the court process or in the ejectment chapter. I would say, this isn't an actual judicial proceeding at this point in time. This is just the notice from the landlord. So it wouldn't necessarily have to comply with Rule 4 unless you all wanted to incorporate that. But
So actual notice as used later in the ejectment actually is further limited.
any notice that would be required in the ejectment chapter would have to comply with the rules of civil procedure. or the language that's in those sections, because there are some tweaks. For example, later on, when you get to the ejectment, there's a new subchapter, and there's a proposal to require the answer from the complaint within 14 days, which would be different from the rules currently, which would be 21 days generally. So there are a few changes later on as it relates to that. For this piece, at least, there was discussion about whether to try to apply this definition of actual notice to the ejectment chapter. And my recommendation to the committee was I would not do that, because then you're really altering the process of how civil cases are handled. And, my recommendation would be to not be carving out just for this in that sense.
Okay, well, that clarifies it. Ken and then Ian.
Saturday and Sunday included in the 5 days?
Yes, sir. Unless you specify otherwise, it would be included.
Is this one of the sections that we have, like, that we should be asking about?
Less so now that I understand that this is the clarification that this definition of the notice isn't carrying over in the
Yeah, that's kind of
really where the notices that we are concerned with.
Okay, in that case, and just very briefly then, delivered by sheriff service, any reason not just like service processor, like more broadly, anyone who can do service?
Good question. I do not have an answer.
And then the other one was for emailed to an email address, including lease agreement, and mailed as described in subdivision Romanet 3. So if you get the email right, but you get the mail address wrong, would that be considered actual notice?
So my understanding of how this would play out, and I should back up, I was not part of any conversation about the sheriff and whether to allow it for some other, kind of service process. So if the committee had a reasoning for that, I can't answer. That was my reasoning for stating it that way. And then, keep in mind that the statute requires actual notice, which is receipt. So if the rental agreement is terminated and the tenant remains, and then it ultimately gets to an ejectment action in court, the tenant would be able to make the argument into court that they never actually received the notice.
Yeah.
And so it is a rebuttable presumption that the individual receives it. So if you did email and mail, I think the court was keeping both to try to ensure multiple avenues of the information getting to the tenant.
Yeah.
If the tenant was able to demonstrate in court that they didn't receive either, the email address was incorrect, and I was, not at the location when you mailed it, then that would be an argument they could make in the court.
Okay.
And there are probably others who have more practical knowledge of how that works out in the court system, and those arguments that are made who could better answer any other questions that you have.
Great, thank you.
Okay. What about a text?
I would argue that because it wouldn't comply with one of the subdivisions here under 1A, that would not be sufficient. It would be in writing, but it's required to be hand delivered, mailed, emailed. And so if it didn't fall under one of those, I would argue it would not be sufficient. Okay. So I'm bringing up actual notice because what I'm going to do now is I'm going to move towards the section in the residential rental agreement chapter where we talk about termination, because again, that's really the foundation here. Before we even get to the ejectment action, these things have to occur. And these can be arguments that are made in the case of the ejectment action. And so that's why I think this is really relevant. But there are a lot of other changes throughout here related to the rental agreement. I'd be happy to answer potential questions if you have them, or to connect with you offline if anyone has questions about what else is in the bill. But I'm going to bring you to this page 7, subsection 4467, termination of tenancy and the notice requirement. So currently, this section is set up where most of these subdivisions are about different reasons for terminating a rental agreement. So for example, the subsection A is termination if there's non-payment of rent. In each of these sections, there's different termination notice periods. that have to be provided. So for example, under current law, if you're terminating for failure to pay rent, you have to provide 14 days notice. If you're terminating the agreement because of breach of the rental agreement, you have to provide 30 days notice. If you're terminating it because of some sort of criminal activity or activity that threatens other individuals, it's 14 days notice. So there's all these different notice periods. And so I'm bringing that up, and I will just kind of walk through each section quickly because the timeframes are being shortened in some instances and then extended in other instances. So for example, here under the sub A, the landlord may terminate a tenancy for non-payment of rent by providing there's the actual notice that's required to the tenant on the date at which the tenancy will terminate, which shall be at least 10 days after the date in the actual notice. So I don't want to walk through each of these subsections unless you all would find value in that. I'm just bringing it up to highlight that it's going to, the notice period that the tenant received is going to depend on what the reason that the individual is terminating the rental agreement for. And I'm pausing on A, and then I'm going to walk through B because these are going to be relevant to the new ejectment language later on in the ejectment section that is really more in the jurisdiction here of this committee. So as I mentioned in the sub A, termination for failure to pay rent. And then they're adding language, or the proposal here is to add language that the landlord may terminate a tenancy under subdivision B1 for repeated late payment of rent. So when you get to B, currently this is broken out into two subdivisions, 1 and 2, where 1 is failure to comply with material terms of the rental agreement or with obligations imposed. And 2 is, and this is here midway through page 8, when termination is based on criminal activity, illegal drug activity, acts of violence, any of which threaten the health and safety of other residents. The proposal here is to expand under the B1. So the landlord may terminate the tenancy for failure to comply with the material terms, obligations imposed, sub 2, repeated late payment of rent, which is more than 3 times in a 12-month period, or the tenant's refusal to allow a landlord or the landlord's agents access to the dwelling unit in accordance with 4460. There's a separate section that talks about when a landlord can actually access the dwelling unit. If the tenant's not allowing access, that falls here.
Barbara, there's a question. So I've got 2 questions actually. Can you say more about what the material terms are of the lease?
There was some discussion in the committee about this. There are other provisions in the chapter related to obligations of the tenant. Tenant has obligations to pay rent without demand. The tenant has obligations to, not damage the dwelling unit, not cause any, habitability or issues for other tenants and their kind of enjoyment of their units within, the premises, for example. So there are certain kind of obligations, and then material terms of the rental agreement could be other things like the lease could say you can't have other people living there. I know a lot of leases say that you can't smoke in the property. I would define that as kind of material terms of the lease agreement.
And a tenant's refusal to allow access, I'd like to understand that better, because if somebody is like, I just had a baby and I don't, want the landlord to come in and spray for insects,
Right.
is that in violation? Or I work nights, and so coming at 8 a.m. is really inconvenient.
So I want to pull up that section. And as a matter of fact, I'll just pull it up here so I can share it with you all. Give me 1 second. Okay, so the landlord needs the tenant's consent to come in, which the tenant cannot unreasonably withhold. there's only a limited subset of reasons in which the landlord does not need the tenant's consent to enter the dwelling unit, and they're listed here under the sub B. The landlord has to provide a minimum of 48 hours notice. And with that 48 hours notice, the landlord could come in to inspect the premises, make necessary or agreed repairs, supply agreed services, or to, exhibit the unit for a potential buyer. So in that instance, I would probably defer to maybe some others with better, practical expertise if the specific situation, if you're looking for an answer to that, if the landlord's saying, hey, I need to come in, I want to spray for bugs, and the tenant is concerned about the use of whatever, material is being used because of that reason, I'm not quite sure exactly how that would play out.
But those hours are sort of limited. I'm thinking of a lot of people who have to be at work by 8 a.m.
So this really isn't part of
or
our jurisdiction.
Okay.
I mean, no, I understand wanting to understand it and definitely can talk offline on
Okay.
all these. No, I just to keep us on track.
Okay.
Understand the concerns, and I'm sure that we individually have concerns with all sorts of parts of this, but.
Okay, so the proposal here under the sub 2 is to remove the specific references to criminal activity or illegal drug activity and just say that when termination is based on acts of violence, damage to the dwelling unit or premises, or other activity, any of which threatens the health or safety of other residents, and then adding specifically the landlord, landlord's agents, or neighbors, the landlord may terminate for 5 days notice, so a reduction there from 14 to 5. The actual notice required for this B shall be accompanied by an affidavit stating forth particular facts and the basis thereof in support of the termination with sufficient details to inform the tenant. And then another piece that was added here is this sub 3, where a landlord shall not terminate a rental agreement under this subsection based on a person seeking medical assistance for a drug overdose, being the subject of a good faith request for medical assistance, or being at the scene of a drug overdose or within close proximity to the scene of a drug overdose as provided. Moving to the top of page 9 and 18.4254. So I'm pausing and doing a little bit of walkthrough of these two sections in particular. These are what, you may hear or, individuals refer to as, quote, kind of just cause reasons for termination. These are reasons where the tenant isn't complying with some requirement or obligation imposed by the chapter, and therefore the landlord is moving forward with termination. This is relevant because later on, the proposal in this amendment is to create a new ejectment subchapter for termination based on these factors alone. And that new subchapter has different requirements when it comes to the period for answer and very, I don't want to say shortened, but shorter timeframes for the court to hold final hearings and issue judgments, et cetera. So that's why I'm mentioning these, because they're relevant when we get to later. And then the last thing I'm going to mention here is this last piece, the sub 3, about person seeking medical assistance. The intent here was to kind of mirror what's in 1842-54 regarding immunity for certain individuals if they need medical assistance for an overdose. So it's really just mirroring what's there in that section for the termination piece. Okay.
So just I want to make sure so it's page 8, 2A is what is going to connect to the show cause.
Yeah.
So why was criminal activity and illegal drug activity removed? I'm curious. Is that covered, or is it considered to be covered in other language in here?
There was, as far as the discussion that I was aware of when I was in the room, there was concern about individuals potentially having their residential rental agreement terminated based on criminal activity when there may not have actually been some criminal charges brought or, a conviction due to criminal activity. There was also concern about, with the illegal drug activity, I think there was concern among all of the members of wanting to address circumstances where individuals may be dealing drugs out of a unit, but didn't necessarily want to have, an individual who may simply be a drug user but isn't bothering other individuals. There's discussion about that. And then I think at the end of the day, there was comfort among the committee that by removing those two, you're still leaving acts of violence, damage, or other activity. And then from their perspective, the key piece here was it's threatening other people. And so if it's threatening other people, that's really the thing that they were wanting to go after. So if somebody is dealing drugs out of a dwelling unit, I think there's still an argument that you could remove that individual because that activity would threaten other individuals.
And also presumably there's, getting ahead of myself, the show cause affidavit, the individual landlord isn't going to be able to say whether it's illegal drug activity or criminal activity for that matter. But
that was part of,
presumably can say whether there's been a threat.
that was part of the discussion as well. Yes, sir. Yeah.
Sure.
Yeah, and I realize this is setting us up, so I'm trying not to get too into it, but I feel like the timing might be helpful for me to understand. So this is saying if any of those things happen, they can give notice that the tenancy will be terminated, and it has to be at least 5 days out.
Yes, ma'am.
But then getting back to the notice is 5 days.
Right.
So it could be you get the notice and you find out your lease is done. You are
So-
now being,
Mhm.
right?
The way it would work, slightly alter that. Think
Okay.
about it this way. If you're going to mail it, the presumption is the person received it 5 days later. And then the termination notice, when they receive it 5 days later, has to give you 5 days. So it would really be, if you're the landlord and you're trying to figure out and calculate, okay, well, when am I actually terminating this agreement? If I'm going to mail that notice today via certified mail, it's really 10 days from now because I have to presume that you're not going to get it for 5 days.
Okay.
And then if this were to pass with this amendment, you would have an additional 5 days. So it would be
Great.
10 days. But the individual may very well only have 5 days if they do only receive it 5 days later.
But not 0 days. So that, I mean, I'm not saying
Correct.
5 days is great, but it's better than 0 days.
Correct. Okay. Okay, so the next piece in this section, I'm going to just mention one more thing here because it's going to be relevant, is apologies for the scroll here. Going to page 13. There's an inclusion of this language here, affirmative defense to an ejectment action. So for any ejectment action based on failure to pay rent, so we're only talking about that. We're only talking about subsection A. It's an affirmative defense of the tenant and judgment shall be issued for the defendant if there exists a serious health and safety code violation issued to the landlord under 20 VSA 2677. 2677 is where the Division of Fire Safety has the authority to issue citations for violations of residential housing codes. So a few years back, you all kind of took the oversight of residential dwelling health and safety codes and put it under the Division of Fire Safety. So they have issued rules that outline what the kind of health and safety codes are required for dwelling units. And so if the Division of Fire Safety has issued a citation under that section, and the landlord, this is under line 14, the landlord has made no reasonable attempt to correct the violation as of the date of termination, then it would be a defense for not having paid rent.
What about eviction?
So think about it this way. Remember, you have the termination. So let's back up. There's a health and safety violation. You, as the tenant, notify Division of Fire Safety. Division of Fire Safety comes in, issues a citation to the landlord. You have to do this to fix it. Landlord doesn't. Tenant stops paying rent, which the tenant has the legal authority to do under a separate section. The tenant is not obligated to pay rent if there are health violations in the unit. And then the landlord proceeds to terminate the rental agreement because you're not paying rent. And then you stay. The landlord brings the ejectment action against you because you're not paying rent. It's a defense for you as the tenant to point to this section and say, you can point to this section and the other section that authorizes you to not pay rent. And you can point to it and say, you landlord took no reasonable steps to fix the citation that you were given. Therefore, judgment shall be issued to the defendant in that case.
What if a health or safety issue is such that the health department or another inspector says, you gotta get out now?
There is a separate section up here in the termination that says if the termination is based on a government requirement or a government notice to leave the premises, then the termination is based on that date, whatever date the government puts in. So if the health department comes in and says you can't live here anymore, then the individual would have to leave and the landlord could terminate the rental agreement based on that fact. There is no requirement to provide the individual some sort of alternate housing. There's a separate section where the tenant is allowed to not pay rent because of some sort of health violation. They can also pursue damages. And so if there's,
Existing law.
yes, sir. So if there's a health and safety violation and the landlord is not doing anything to fix it, then the tenant cannot pay rent. If the tenant ends up having to leave the apartment, they could sue the landlord and seek damages in that event. I don't know how successful that has been in the past. I would defer that question to others, but at least conceptually, it's authorized by the statute.
And they probably would have been asked to leave with the first of, I want to say eviction notice, but once the landlord got their first warning, if the problem was big enough, then they would have been directed to leave, other than potentially the second contact. Okay, thank you.
Ian, Barbara, Tom.
Does the health safety code identify serious violations and non-serious violations, or is it like a subjective thing? There's a violation, we have to make a determination as to whether it's serious or not.
It gives this list here. So the list that's in statute says conditions jeopardizing the security of the unit, major plumbing leaks, flooding, gas or fuel oil leaks, electrical conditions that could result in shock or fire, moving to the top of 14, no heating system, utilities not in service. So there is an inclusive list here. As far as whether something else that's not here fell under a serious health safety violation, I assume that's going to be a determination of the Division of Fire Safety at that point. To what level of seriousness is the violation according to their rules?
Yeah. Okay.
Barbara, Tom, Ken.
So, on page 13, I'm wondering how much it gets into what the reasonable attempt is. Like basically, if the person still is not, if the issues are not fixed, like if it's sort of like a pretty weak effort that a landlord made, the landlord might think that's reason. I get so.
Yes, ma'am. It's not defined. So ultimately, a court would make that determination of what would be reasonable. My understanding is the Division of Fire Safety, at least according to that statute, they should be providing landlords with a specific time frame of, fixing those citations. So, if they were supposed to be fixed within a specific time period and it's, 30 days after that later, the landlord may want to make a case that that's not reasonable, but it is not defined terms.
Tom, Ken, and Karen. I didn't want to leave notes.
Good.
I'm wondering if, to process, the landlord being issued a citation for something, if the tenant is also notified in that process.
I'd want to go check 2677. I do not remember. I have to look.
I was just curious.
Thanks. So let's just go back to something that happens all the time. As simple as trash. The tenants just load up with trash. They won't take the trash out. The next thing you know, you got rodents, you got everything in there, right? You've got the safety feature. I assume that was fall under the safety feature of the if you have more than one unit in there, right? That becomes more of an issue with that. You can't get in, it smells, it does everything, and it happens. I know it happens. Probably have experience, and you can't get in there. Then I'm hearing the court system. The court system could take 30 days, could take God knows how long, right? You're putting more and more in jeopardy of your other tenants. Where's the fallback on that? Because the process hasn't been speeded up at all from what I'm reading and hearing. How are we dealing with that?
So I will say, going back to the access piece, the landlord can gain access to the dwelling unit if there is a threat of imminent danger to a person or the premises. And so,
That's 5 days.
nope, could go in at any point. The landlord could, if you were saying, if there's, trash building up and it's smelling and there's potential for rodent activity, et cetera. I'm saying that the landlord could access the dwelling unit at any point if there is a imminent threat of danger to the person or the premises.
Okay.
So I'm saying the landlord may be able to go in immediately and try to, address the issue that's going on in the unit.
Yeah.
But then if you're talking about the timeframes here, I would say that the timeframe for termination in most instances that are kind of what I call the kind of just cause instances. So similar to what you're outlining here, if somebody's not complying with the terms of the agreement, you have to maintain a clean premises, or you're destroying the property because you're leaving trash everywhere, et cetera, then the time frame is shortened to 21 days under this proposal. I'm just trying to get there. So that would be under B1. It's currently 30 days, and this proposal would reduce it to 21 days. Unless you as the landlord are going to argue that the termination is based on damage to the dwelling unit here, in which case it would be shortened to 5 days.
However, as soon as that happens, and if somebody's living with the trash thing and what's the other big thing that's happening now where it's just a cluster of mess in there and all that, hoarding and all that. That'll fall into more health reasons, maybe mental health. I don't know how they'll do it. The tenant will go and file more, because a lot of them know how to do this. They will file more into the court system, and it's going to tie it up more, and the landlord's hands are tied. They can't do anything, putting the other tenants in more at risk. So I'm still not seeing how we're fixing a problem of safety for other tenants, and also the owner of the building that's probably got payments to make on it, as in a mortgage and taxes and all that.
So I think he's getting to that part of the objection component in the expedited way. I think that should hopefully answer some of their issues.
Okay.
I would say for at least the proposal here, if it's for non-payment or for some sort of a breach of the rental agreement terms, the termination periods are being shortened. As far as whether somebody could, as you mentioned, going to go to court or tie things up that would delay that action. I'm not a practitioner on the ground in this case, so I would defer that question to some others who may be better able to answer how these things actually play out practically on the ground. So,
Thank you.
the last thing I'll comment here on this affirmative defense is this sub 2 on page 14, which is the remedies for the tenant in that instance are not available if the serious health and safety code violation is caused by the tenant's negligent or deliberate act or omission. So the tenant can't cause the violation and then subsequently take advantage of the defense after that. Okay, now we're going to get to the ejectment provisions, which is really where our input seriously starts. But this is important background because
Rest of person.
this
That's the background for the section that.
Okay. So beginning here on page 15. This is adding a section into 12 BSA 663. Which would authorize alternate service of process throughout a proceeding if it's been issued by a court. So this isn't necessarily going to be limited to an ejectment case. But so what this section is saying is if the court orders that alternate service of process be made in a civil proceeding, this is here on line 8, the order shall remain in effect and apply to all subsequent service of process in the same proceeding, including post-judgment proceedings. The section shall apply to orders issued pursuant to Vermont Rules of Civil Procedure 4D1, permitting service of process by publication or by leaving a copy at the defendant's dwelling house or usual abode. So just that, if you go in and you file a motion and you're seeking some sort of alternate service of process, then subsequently that's going to apply to all of the notice requirements to the remainder of the proceeding and not for whatever that instance of notice or service that you're seeking. Okay. Then when we get into the next piece here, which is chapter 169 related to ejectment specifically, there's a change here in service of process to say, unless otherwise provided by law, the process shall be served and notice given as in all other civil actions. So if you're making the change above regarding the alternate service of process throughout, this is simply making a corresponding change in the ejectment section to say, unless otherwise authorized. So those two sections just kind of go hand in hand. Okay, so before I move forward, I'm going to just kind of comment that, as you can see here on line 1, there is currently a process in Title 12 regarding ejectment for the circumstances we've been describing. When a tenant remains after the date of termination that's been provided in the notice, the landlord can go into court and pursue an ejectment action. So this statutory construct currently exists. Within that, there are two sections to be aware of. One of them is this piece right here, 4853. The landlord, at the time they're bringing the complaint, or separately after the complaint's filed, the landlord can ask that rent be paid into court during the process of the ejectment case. And so the first change here is simply fixing a statutory issue where there are currently two subsection A's. They were amended in the same year, way back in 2007. They currently both still exist. And so my recommendation to the House General Committee was to clean that up. And so they have struck the first instance because the second instance is a little bit more descriptive. So as I mentioned in the sub A here, in any action against a tenant for possession, the landlord can file the motion to have rent paid into court.
Thank you.
What this change does on page 17 is the court can order either full payment of rent. So if the monthly rent is $1,000, the court can say you need to pay $1,000 on this day into court. Or the court can issue partial payment of rent. So it's not obligated that the court order the full payment. The proposal from the House General Committee was to remove the authorization of partial payment. So the court could only order full payment at that point in time. And so that's what those two amendments there are, just striking the word partial from D. And then the subsection G is the tenant may at any time apply to reduce the amount ordered. And so it would remove the authority of the tenant to seek that.
So the court can now, with this language, can only order full payment?
Yes.
And would that stop a landlord and tenant from making a deal as far as payments go?
Not to my knowledge, based on anything in the statutory language, but I would defer that question to the judiciary or to others who are practicing in this area of whether they feel that this change would somehow limit their ability to seek a settlement during some sort of agreement for an alternate or an alternate amount for a different.
Says full payment, I didn't pick up, is there a timeline on that where that would be?
What's not in this section, and so I'm pulling this out, there is in the sub B, it says that a hearing on the motion, so the motion for,
What page are we on now?
here, I'll pull up the statutory section so we can review it, because it's not in the bill, because it's not being amended.
Yeah.
Okay. So this is that section in the Superior Court ejectment subchapter 4853A, excuse me. So the motion is filed. And the sub B, it just says that the hearing has to be held at any time after 14 days notice to the parties. If the tenant appears at the hearing and has not previously defaulted, the court shall not enter judgment by default unless the tenant fails to file a written answer within 14 days after the hearing. Any rent or escrow order shall remain in effect notwithstanding the issuance of a default judgment, but shall cease upon the execution upon the conclusion of the case. And so if there is opposition, a memorandum of opposition filed, it has to include an affidavit setting forth particular facts of why. If the court finds the tenant is obligated to pay rent and fails to do so, the court shall order full or partial payment into court of rent as it accrues. So conceivably, the tenant is still living in the dwelling unit. They're still obligated to pay rent while you're bringing the ejectment action. And so D is saying that if the court finds that the tenant is obligated to pay and they're not doing so, that's where you shall order full or partial payment, gives the option. And the proposed amendment is taking away the option of the partial. So the court in that instance, you're being ejected, you're still there, you're obligated to pay rent while you're living there. We're going to order that you pay the full amount into court.
So I
I
think.
hate to get off on a.
No, I had some similar questions and I'm gonna ask questions of not necessarily you, but other witnesses flag it for them right now that there are rent escrow days at the court where they have landlords and tenants coming in these situations, and often they get agreement between the tenant and the landlord of paying partial, and this would take that discretion away, and I think it takes the.
Well,
It makes it,
where I was going.
inability for the parties to agree to something and for the court to enter it. So I flagged this as a concern and we'll add further get this disputed.
My next question was gonna be, maybe for somebody else, is why that was changed.
I think I won't speak for the committee. The conversation was, concern about, the landlord has their own obligations and the rent was agreed upon of a certain amount. And that was some of the discussion, and I'll leave it at that. You're raising good questions, and there is also later on in this new subchapter, a period about where the tenant or defendant has a specific time frame to cure a complaint brought due to failure to pay rent, and they have to cure that within a very specific time frame, or they lose the right to cure as a matter of law, is how the language is written. I would raise the same question that you have maybe to the judiciary and to the advocates, as whether that would prohibit some sort of ongoing negotiation of the parties during the process that the ejectment is playing out.
If this isn't ours, they had their discussions over there about it, and I would be inclined to leave it alone and not change something they did if it isn't ours. If it is ours,
I think when it comes to court discretion and taking away court discretion, that definitely is enough.
okay. I think it's at least worth the conversation.
Yeah.
I mean, this is about civil court process, so I think I'm not here to advise you what your jurisdiction is, but I think it probably falls within your jurisdiction. Okay. So moving to this next section, this is about property of the tenant remaining on the premises after eviction. There is a separate section before this, I think it's before this, but it says that when the landlord is, if the landlord is, issued the writ of possession. So they get the judgment in the ejectment action. That has to be served by the sheriff. And then the language says, this isn't in this amendment, but in the statute, the language says that not earlier than 14 days after the sheriff serves the judgment on the tenant or the defendant to remove the individual from the property. So arguably, there is a statutory 14-day minimum period where after the judgment is issued and served to the individual would have that 14-day period to vacate and remove their belongings before the sheriff would come back and then change the locks or remove the individual. This section says that the landlord can dispose of property remaining without any liability 15 days after the writ of possession is served or upon legally being restored to possession of the dwelling unit. So the discussion was judgments issued, served to the defendant, potentially a 14-day period of waiting before the sheriff comes back and removes the individual. And then at that point, the landlord would have to maintain the property for another 15 days after that. Because of this section says it's 15 days after it's served or after the landlord being legally restored to possession, whichever is later. And so that time period could be ultimately 21 days if the entire period is carried out. And the committee felt that that was too long. They felt that after this entire termination period and ejectment process has played out, the judgment is served to the defendant. They're given at least another 14 days. That at that point, when the landlord is restored to possession of the premises, the landlord should be able to dispose of that property at that point. So that's what this section is doing.
So where's the 14 days again? Remind me where
It is,
2 days.
Yeah. Oh, it's not.
it's in 4854. So court finds the plaintiff is entitled to possession. Plaintiff has the judgment for possession and rents due, damages, etc. Writ of possession shall issue on the date the judgment is entered. Writ shall direct the sheriff to serve the writ upon the defendant and not earlier than 14 days put the plaintiff into possession.
Okay, so not earlier, it could be earlier than 14.
Yes.
There, and
Yes.
then this 15 days is added on to it, under current law, but there's. Okay.
And I will say I was not in the room, but I was informed by the committee that there was some discussion they had certain sheriffs or law enforcement officers come testify about these provisions as they go hand in hand about delivering a service and when can the landlord remove the property. And there appeared to be some confusion or disagreement about the timelines. Some individuals, I was not there. But I was informed that some individuals testified that the language is, even though it says 15 days, they were interpreting it to be 15 days after the writ of possession is served, which means when the landlord is restored to possession after those 14 days, that, you wait a day and that's 15. I read the statute differently because it says it's 15 days after the writ is served or upon the landlord being legally restored, whichever is later. Presumably, the landlord is going to be legally restored later in most cases. I can understand a circumstance where maybe not, but I'm just highlighting for you all that some individuals read this section different than I'm reading, but I think the language is pretty plain and clear.
If there is a 14 days before.
It's a 14, and then this would require an additional 15.
And I would say that this is really not, this is House General's decision on that, because it doesn't really involve quite the problems. We have problems with it, but again.
Okay.
Not right.
Can I just ask you a question about that?
Yeah.
So as you know, I'm not a lawyer, right? But this whole document screams, uh, judicial. This whole thing.
Yeah, but there are parts that the other committee has jurisdiction. It overlaps some, but there are certain decisions that they are making after weeks of testimony that don't have anything to do directly with the court process. And this language right here that we just looked at, it's not directly related to the court process. It's not impacting timing in the court. It's not impacting discretion of the court or any of those things. So I know it's sometimes not a clear line, but I think with respect to that, that's not, individually we can weigh in on this, but just as a committee, it's not really our jurisdiction. Just that section that we just looked at, the property of tenant remaining on premises after eviction.
I'm sure how to go with, bring this up. Service of the writ of possession. You're waiting 15 days before they remove the tenant. 14 days, sorry.
Yes, sir.
And then 15 days to return the or take the property.
You would have to hold that property for an additional 15 days before you could dispose of it. Under current law, and this proposal is to change it to immediately. Okay. So here we go on bottom of page 18. What this is doing is it is creating a new subchapter in the ejectment chapter. So as I mentioned a bit ago, subchapter 3, there already is a process for bringing the ejectment case. This is creating a new subchapter. So it's going to create kind of an alternate ejectment, the capacity of a landlord to bring, a case in a different subchapter than the one that already exists. So you could have potentially 2 separate types of ejectment cases going. The sub 4861 here is saying that this is limited to the terminations under 9 VSA 4467 A and B. So that's why I kind of wanted to talk about A and B earlier, because what this is saying is this ejectment process is only for terminations due to non-payment of rent or for breach of a material term of a rental agreement, for breach, obligations, activity that threatens other individuals, etc. So we're only talking about terminations in those 2 instances. The sub 4862 on page 19, it really just mirrors a lot of the current language that's in statute for current ejectments. The process issues as a summons, requires the defendant to appear and answer, and shall include a copy of the rental agreement, if any, and the notice to terminate. And then it also mirrors the previous subchapter about either party having a right to a trial by jury. 4863 is the answer period. Here's where it starts to change from what currently exists. This section would require that the defendant file an answer within 14 days after service from the complaint. And that is different from the current process, which would follow the rules of civil procedure, generally require 21 days. So this is the first instance where it's altering what currently exists, both in an ejectment action, but under your rules of civil procedure globally. Answer shall be, the answer to the complaint has to be accompanied by an affidavit setting forth the facts. Okay, this next C1, this is what I mentioned earlier about that cure period. So this says that if the complaint is due to failure to pay rent, this is on line 20, the defendant may cure the action by paying all rents owed, court costs, and service fees by the answer date. So the individual would have 14 days after the complaint is filed to pay all of those monies. If payment is not received by the answer date, moving to the top of page 20, the defendant shall lose the right to cure the complaint as a matter of law. A plaintiff may accept payment in whole or part and dismiss the complaint. the defendant shall not have the right to cure in subsequent action. And this was my point, was you may want to ask the judiciary and other external parties of whether they feel this may restrict their ability to have ongoing settlement during the case. Upon, this is in the sub 2 here, upon receipt of the answer, if the termination is based on A or B1, the court shall set a hearing date not later than 60 days after the date of the service of the complaint, absent good cause. My understanding is that's, a pretty significant difference to the current, authority of the court when it comes to when to set hearings.
That language, I want to make sure that was not.
It's on line 7, page 20. There is no similar general time frame built into the current ejectment chapter. There's an expedited process for specific circumstances in the current ejectment chapter, but this is saying that any complaint brought under 4467A or B1 has to be decided within 60 days. Then you get to a section around defaults. The defendant fails to provide the answer, plaintiff shall be entitled to possession.
Can you back up just for one moment? I want to
Yes,
make
sir.
sure I'm following. So this process, I'm just trying to go back to the reasons for the termination. So you have back on page 7 and 8, you have subdivision B 1 and B2. Right. So this whole process applies to both.
The new subchapter would apply to A and B, both B1 and 2. This new subchapter would apply to all of those. This language here, though, that says that the final hearing has to be within 60 days is only for A or B1, not for a termination brought under B2, which is the termination that is threatening the health or safety of the other individuals, the landlord, neighbors, etc. So
B2 is covered by then.
B2 is going to come up here in a second related to this show cause hearing.
Okay, thank you.
Language. Yes, sir. But thank you for pointing that out because I needed to point it out to you.
Some time frames and establishing time frames for the failure to pay rent, for instance, and some other things.
Failure to pay rent or failure to comply with the material terms of the agreement, repeated late payment of rent, not allowing the landlord access.
Right, okay.
Those reasons, they're going to be required to have a final hearing in 60 days. Now, if you get to the circumstance where it's a termination because of the threatening activity, so the language specifically is, make sure I get it right. Termination based on acts of violence, damage to the dwelling unit, or other activity which threatens the health or safety of other residents, the landlord, or the neighbors. If it's one of those reasons, you have this section called show cause hearing. So, and it says that if the complaint is based on a termination for one of those reasons, the court shall set a show cause hearing within 10 days after an answer is filed. If the defendant fails to appear, plaintiff is awarded possession. Sub B, moving to the top of page 21, at the show cause hearing, defendant shall provide a rebuttal to the facts supporting the termination claims brought. Sub C, parties may rely on affidavit evidence during a show cause hearing made under the pains of penalties of perjury. If the defendant makes a showing that live testimony is required, or upon the court's own determination, a final hearing may be ordered. In the event a final hearing is ordered, the final hearing shall be set within 21 days after the date of the show cause hearing. So if you're terminating and you're bringing an ejectment action because of one of those reasons that threaten health or safety of other people, other tenants, the landlord, or the neighbors, first you have a show cause hearing within 10 days after the answer. So remember, the other sub said 60 days after the answer, you have to have the final hearing. This is saying 10 days after. And then that can be based on affidavit evidence. If you need a final hearing, 21 days after that. So it would be arguably 31 days total, or at least the final hearing would have to be 31 days after the answer for terminations under that B2.
So are there, what are the standards for what has to be in a complaint to lead to a show cause hearing? Is that laid out anywhere?
If you recall, at least in the termination notice itself, has to include an affidavit setting forth particular facts and the basis thereof in support of the termination with sufficient details to inform the tenant of the reasoning behind the termination. So that would have to be included. Outside of that, it would just, the complaint itself would need to comply with, the requirements of your rules of civil procedure regarding what needs to be in the complaint.
So the affidavit has to be included with the complaint?
I believe so. The initial affidavit has to be included with the termination notice provided to the tenant.
Right. But then does that get forwarded to the,
And then 1 second. Just wanting to get to the beginning of this section. And then when you get up to 4862 at the beginning of this new subchapter, that notice to terminate has to be attached to the complaint. So the information that was provided as part of the termination has to be included as part of the complaint.
okay, thank you.
Okay. Next section here, costs and judgment, really mirrors what exists in the current subchapter. If the court is finding for the plaintiff issuing the writ of possession, having the sheriff serve the writ not earlier than 14 days, put the plaintiff into possession. So same time frames there after the judgment's issued. And then 4867, the property mirrors the change above about the landlord being able to dispose of property immediately. Then we get to page 22, where we're going to start talking about trespass. So that's the new subchapter related to terminations of these two areas.
Just before we go on to the trespass, okay, so we've got these two processes. One is for the subdivision A, one's for the B. The A one, you have a right to a jury trial. The B one, you're going through this kind of show cause hearing and maybe a final hearing. If the show cause hearing is like an in-person hearing that the parties can proceed by affidavit on, and then the final hearing could also be an in-person hearing, but there needs to be a showing either by a party or the court's own discretion that they need another hearing. Then that one would also be an in-person hearing where they need live testimony.
So a few.
Yeah, I'm trying to just make sure I understand.
A few things to alter there. This new subchapter would govern the, quote unquote, just cause termination reasons.
Yes.
So if you're terminating because of A or B.
Yep.
If it's A, non-payment of rent, or B1.
Sorry, yeah, it was A or B1.
Yes, sir. Then you don't need the show cause hearing. You
Yep.
just have to have the final hearing within 60 days.
And that final hearing could be a jury trial?
Individual could have a right to a jury trial for any of the any ejectment that's brought.
Okay,
any of the reasons.
that is
Any of the reasons.
above.
And either party could ask for it.
Okay,
And so for the A or the B1, any final hearing has to be within 60 days. If it's for the B2, because of some sort of acts that threaten, the health and safety of other people, then you're going to have this show cause hearing in a much shorter time period.
Yeah.
At the show cause hearing, both parties could provide affidavit evidence under penalty of perjury. I would defer to the judiciary on how they would go about doing that. And then if there is a need for live testimony. So some of the discussion in the testimony in the House General Committee was how are you proving that these individuals are, threatening or violent against their other tenants? The other tenants may be dissuaded or concerned about testifying against someone in this hearing if they're worried about that individual being violent against them. This is the discussion. I'm not saying this is, you can imagine this being the case. And so they may not want to go into court and testify. And so that was, from some of the advocates, that was the concept of doing the show cause, was you have the initial hearing, you can use affidavit evidence if live testimony was required because the court was not comfortable, there's conflicting, conflicting testimony in the affidavits, then they can request that live hearing. And if they do so, it has to then be within 21 days. After that. Yes, sir.
Great. Okay. So I'm just, I appreciate the sort of summarizing of it. It's very helpful.
Okay. Page 22, this new section says, after being legally restored to possession of the dwelling unit or leased premise pursuant to the chapter, the plaintiff may issue to the defendant an order against trespass for the entire premise subject to the ejectment action in accordance with 13 VSA 3705, which is where you have the language regarding trespass orders. So then this next section here, related to trespass, is really incorporating a bill that is in this committee, H 728. I believe one of the members at the table can speak intimately to this. But so it has a purpose statement, the purpose being to, overrule the Supreme Court's decision here in State v. Dixon back in 1999. And this would then, in section 5, amend the unlawful trespass section. So in sub A, a person can issue a no trespass order if the person, it has to be the person in lawful possession has to issue that order. And then this new G1 is saying, notwithstanding that sub A, the landlord can issue an order against trespass if, in page 23, one of the following conditions are met. The tenant agrees or consents to the order. The invitee or licensee subject to the order is violating terms of the dwelling unit's lease agreement, or the invitee or licensee has violated a state or federal law while on the premises. And then it has a specific appeal period, and then it references the definition of dwelling unit and tenant to the residential rental agreement chapter. So it's expanding trespass to authorize the landlord to issue the order of trespass against somebody who's on the property, either conducting illegal activity, violating the dwelling unit's lease terms, or if the tenant requests the landlord to do so. Okay. And then we get into the next few sections here are about ejectment records and the confidential nature of those records. So this would be adding a new subchapter 5 under the ejectment chapter. So if you recall in the ejectment chapter, I mentioned you have the current subchapter 3, which is about current ejectments. New subchapter for these expedited ejectments for certain termination reasons. This adds another subchapter about confidentiality of those records. Mm-hmm. I'm not going to read this word for word because I know you have a lot of other witnesses. But 4872, all newly filed ejectment complaints would be confidential upon filing, and they would remain confidential unless the confidentiality is removed based on 4873. New section 4873 states that if the court of jurisdiction issues a final or a default judgment in favor of the landlord due to termination based on that A or B. So only terminations based on non-payment of rent, breach of the rental terms, or threatening activity. If the landlord gets the judgment at the end of the case based on one of those terminations, then it would be unsealed, or I shouldn't use the word unsealed. It would lose its confidential status at that point. And then there's a section stating the next section is, if it's confidential, the person may answer that there wasn't a prior ejectment. And it states that consumer reporting agencies have to comply with the confidential nature and reporting any information as part of a tenant screening report. A tenant who is injured based on a consumer reporting agency reporting information that would be confidential would be able to bring an action for injunctive relief or damages. The section 4875 states that the parties to the case, the judge, the court staff, or the attorneys representing individuals can access those confidential records. And then the court can make the records that are confidential available to any person with a valid court order. That is it. The remainder of the bill is about a credit reporting pilot program and positions, appropriations, et cetera.
Great, appreciate it. Thanks for the great walkthrough. Yeah, go ahead, Barbara, ask a question.
So I think I just was losing it at the end, but so if somebody is, if the records are confidential and I'm a landlord and I want to rent to Ken and Ken just had a confidential eviction, are you saying that if I call Tom, who used to rent to Ken, Tom is going to say Ken didn't have an eviction?
The section is limited to the records that the court has. So I don't see anything that would prohibit if you're doing some sort of reference check from an
Tom will
individual.
say, I took Ken to court and evicted him.
So confidential means, is the definition, confidential means to limit access only to those persons who are authorized by law or court to view the record. But then when you get down to ejectment record is a recorded information pertaining to an ejectment case that is in possession, custody, or control of a court, or was in the possession of a court. So I'm not aware of anything that would prohibit an individual who is aware that the ejectment was brought or that someone was ejected from reporting that information.
Okay, so it's just the court papers, but and for example, could not put Tom down as a reference. He might not get the apartment because he doesn't have a formal landlord's reference.
The way I read the language as it came out of the committee or is proposed, in the instance that you're describing, if the case remained confidential, you would not have to disclose that you were ejected. But if you provided a reference or the individual knew that you used to rent from someone and contacted that individual and that person said, I had to eject that individual, I don't believe there's anything in here that's going to prohibit that from happening or there'd be a consequence for that action.
I'm relating it to employment. When I used to, when I had a number of employees, and sometimes you have to get rid of somebody and they go apply someplace else. And I would never tell anybody I fired anybody. I would just tell them I wouldn't rehire them. Thank you for what it is.
And not to go too deep on that, but what Barbara was just saying about the Ken and the Tom thing, right? Like I would never go and say I evicted somebody or something like that, because I just want them out of there and out of my life. And then throw that person on somebody else, which happens all the time.
Yeah, I get sued.
And then you're student, but.
All right, so we're gonna have to change, I'm afraid we're not gonna be able to get through all these witnesses today because I'm gonna be losing quorum at 3:00. And I do want to hear from Judge Zone, but we'll reschedule other folks, and I really apologize, but I assume that you probably wanted to hear what this was all, the testimony was anyway. But I do want to just jump to Judge Zone and Carrie Carsones if she's going to weigh in. So thank you very much, Cameron. Great.
Yeah, thank you very much.
I'm going to remain with you.
Yeah, no, that's great.
Counselor too.
The chair awaits.
Over to Judge Zone.
You get your own chair.
Good afternoon. Tom Zone, Chief Superior Judge. I did hear the chair at the beginning, and I will focus on the areas that have to do with the judiciary and the impact on the courts that fit within this committee's jurisdiction. On page 8, line 14, it talks about the actual notice being accompanied by an affidavit setting forth particular facts and the basis therefore. This is an affidavit that has to be served upon the defendant, the tenant, with the actual notice of termination. It's unclear what particular facts and the basis therefore means. Does it mean you were selling drugs? Does it mean you were selling drugs on this date? Does it mean you're selling drugs on this date to that person? In other words, I think that there's going to be some questions about whether or not whatever is being filed is sufficient and what we can identify from that. Is hearsay, secondhand hearsay, is that going to be a particular fact and the basis? So I just put that out there as something that may be an issue. Subsection B.
Can I ask a question on that real quick? This is, unless you have more on that one subsection. No, so is this because, that notice is not just for termination, but that's a notice that, or the affidavit, I should say, could be arriving at court as part of the complaint, and that's where it starts becoming a little bit more of a problem.
Well, yes to that, but I'm not sure that I would necessarily agree that it has to be filed with the complaint. I think that's actually an open question, because the complaint, if you go back, and I don't have the number in front of me, the complaint says that you have to, the new statute says that the complaint has to attach a copy of the notice of termination. If you look here on page 8, the affidavit accompanies the actual notice of termination. So a reading of that may well be that an affidavit is not part of the notice of termination because it accompanies it and is something separate and distinct. If that were the interpretation, then the later section that says what has to be filed with the complaint would need to include also the affidavit that was filed. And if that occurred, the answer to your question is yes.
With all that, we still need to clarify. You got that, Cameron? Yes, sir. All right. Karen has a question.
So to your original point about that particular facts is kind of vague. And I'm guessing that's because before it was specific to there's either criminal activity or illegal drug activity that was very specific. And now we've opened it up. And so is that what we're looking for, to be able to give more understanding of why this activity?
Under rules of civil procedure, we have what's called notice pleadings, and you have to put the party generally on notice of the facts that you are relying upon in seeking relief. What this seeks to do is to focus more and let the tenant know these are the specific facts. That if there's going to be a termination of tenancy for certain for illegal activity or whatever it may be, these are the facts that we're relying upon so that they have knowledge of what they are. And I suspect the reason that's put in is because of the other procedures, whether it's the show cause and other matters that have been added, because this sets in motion a course of events that currently does not exist under Vermont law, because there's significant changes to the process for landlord-tenant with the new bill.
So it would seem under, this is under subdivision B2, B2B, and it would seem that the particular facts would be implicitly related to 2A, the acts of violence, the damage, the threats to health and safety and the like, but you're thinking that that needs to be spelled out a little more clearly?
I'm also thinking that when we talk about particular facts, it's important for the committee to understand that that's not a bright line.
Right.
Oftentimes in litigation, there will be filings to say we need more particularized facts from the other party because we don't understand what it is. And so if a landlord were to file something saying they sold drugs, period, would everyone in the committee agree that that's a particular fact? Well, on one level it is, but others may say, well, that's not particular for here. And so I'm just pointing out that I think that this will need further, it will be addressed in courts in a way that is not as clean and direct as some may hope.
So we might not be able to fix it in legislation. In other words, this could be a case by case.
I could foresee circumstances where defense argues that the facts weren't particular, therefore you never conformed your notice of termination to what was required, and you have to go go back to chutes and ladders. You go all the way back to the beginning. That would be a potential argument courts will have to wade through.
Right. Okay.
So, and if that happens, that's multiple court proceedings going back and forth. So
Potentially, or
Yes.
multiple filings at least.
negating the fact of us trying to, okay, it's helpful.
Okay.
The second section that was on line 18, a landlord shall not terminate. This is the section on medical assistance. And I understand the intent here. Title 18 very clearly identifies that if it's section 4254, reporting a drug overdose, immunity from liability. And what it talks about is a person who in good faith and in a timely manner seeks medical assistance for someone who has experienced a drug overdose shall not be cited, arrested, or prosecuted for a violation of this chapter. And then it also goes on to talk about some alcohol chapters. Subsequently, it talks about that the same provision, the same lead-in, it says the person cannot be subject to violations of 13 VSA 1030 for violation of a protection order. And the reason I point that out is because if you look at the language here, it says on page 9, line 1, and evidence obtained from the good faith request for medical assistance for a drug overdose shall not be used in an ejectment action. That is broader than the Title 18 type immunity. Title 18, as I just noted, says that you can't use it in a Title 18 chapter case and certain Title 13. This said that the landlord can't use anything in the ejectment action. What that would mean is that even if the landlord came in and found evidence of, let's say, human trafficking when this occurred, he cannot use it under the way this is, if they found out because of this. And so I think that there may be some consequences with that broadening that may not be intended, but again, that's a statutory question. Page 15. This is the section on alternative service of process. I would first note that this is for, as counsel pointed out, as alleged counsel mentioned, this is for all cases, all civil. This isn't just landlord tenant. And we've talked about this in your committee earlier this year about TAC orders and the due process, the constitutional protections, due diligence, showing reasons why. The entire structure of those types of orders is routed in due process, and the courts can assess the specific facts to determine whether due process is met and whether it's necessary. There may be reasons to have it at the beginning of a case, and yet the defendant arrives and there's no reason to have it after that. In other words, it is dependent on the facts at the time of the service. I'm unaware of any situations where courts have been unable to decide motions for alternative service in a way that addresses the specific facts with regard for due process. And I would note that it talks about on line 18 that the court has to decide these motions in 3 days. Leaving aside 3 days, it's important, as I've said a number of times, that to keep, when we have these types of statutes that try to put in deadlines for judges to reach decisions, addressing motions and issuing decisions is a core central component of the judicial function. Determining what matters are properly submitted, is everything here that we need to rule on. The order in which the judge is going to look at cases and address them, and the time required for the judge to carefully deliberate these motions and orders are traditionally recognized as matters within the core judicial management. This gives rise to questions that I suggest we don't need to go into with adding deadlines for timing for judges to act. Judges will act and do act promptly and in prioritizing matters as we need to. Are there times where parties may say, well, I filed this case and yes, and something may have taken longer than any of us would like? That can happen.
Yes.
But I would suggest that overall, we understand the prioritization of these types of cases and these types of motions, and that, first of all, again, we don't need to add statutes that say the judge essentially, if you do it once for alternative service, it's forever, because I think that gives rise to additional questions. And then as far as the timing, 3 days, what happens if the court doesn't? Does that mean it's denied? Does that mean it's granted? I would, again, just say that adding timelines for judges to make decisions is not a road that should be gone down.
And I think, as you know, in this committee, that we generally follow what you're saying, but we have been allowed, you have not objected to us using the word promptly. That should go without saying. Maybe we should go through all statutes to get rid of all promptly and all those things some other time, because pretty much we're getting to the point where we're always telling you to rule promptly. Maybe we can find some cases that we can say, take your time at the end of it.
Let's get the backlog.
Or no, we'll be a little more concise. We'll just say no hurry for some of these other ones. But I think promptly, would that be objectionable?
I don't have a problem with promptly, but as you point out, we try, and that's certainly our goal. But if that is something that works for the legislature, we understand that message.
So let me back up to A. So as I'm understanding, it's the first sentence and actually possibly the whole provision that's not necessary. Because 4D1 has to be used anyway. And I think that without that first sentence, and that's if it doesn't make sense that you've established that you can do TAC orders at one point of time, that you have to do it the rest of the time. That's what I'm hearing.
That's correct. I mean, I can give you the example. If you do a TAC order and then you learn the person was in the hospital and now they're not in the hospital anymore, and they're living somewhere else, does the legislature really think that we should continue to do TAC orders that were issued initially, or that we should say, well, no, now you know where they are, go serve them?
Right.
They're just engaged now.
Okay. All right.
Page 17, the top section. This is the committee was questioning before. It removed the word partial. This limits discretion to the court. If we're doing a rent escrow hearing and there's claims about habitability, the court, let's say the rent agreed to is $1,000, but the court hears evidence that something is not right, and the court thinks, well, it should only be $800 based upon what's missing on habitability, at least now. This removes that type of discretion from the court to enter an order that would provide the landlord with a just sum of money based upon the court's findings. And while, again, typically my understanding is that it is in full, there are limited times where partial may be necessary in the court's view based upon the evidence. And so, limiting the discretion here, that's a legislative decision, but I'm not sure it's necessary. Page 19. Line 15. This, as Ledge Counsel noticed, this 14 days is not usual. Civil claims are 21 days. I would suggest that where all of our other dockets are 21 days, this may very well sow some type of confusion. People who may have had other litigation are going to look and not see the 14 days, because right now, if you go on the Judiciary website, our forms for civil cases says 21 days. And so now we put another form up there that says 14 days, and a litigant goes up, looks at the wrong form, and then we're getting motions saying, I got the wrong form, I read the wrong form, or I didn't read the summons close enough. I just don't, it's up to the legislature if that 7 days is worth the potential or having a carve out. On line 17, it says an answer to the complaint filed must be accompanied by an affidavit setting forth particular facts. Back to my point about particular facts. If the complaint says that you dealt drugs and you dealt it on this date, and is it a particular fact to say, no, I did not, period? I don't, if they weren't even in the state, how, and they say that, is that sufficient? So it also, we don't have cases generally where you file an affidavit in response. There is a verified complaint in foreclosure that is required. But I just point out here again that this question of particular facts in the answer, it's new, it's different. And what if they don't file particular facts? Is that a default? Does that entitle the plaintiff to judgment? And so that's not clearly spelled out what happens if they don't file that. Do we give them additional time to file it? On page.
Yeah, a question here.
So I'm hearing the facts piece is new. Did I also hear you say the affidavit part is new too?
Correct. Yes.
And somebody can't just create an affidavit on their own, can they? How do they do that?
No.
Yes. Oh, so it's a process. Okay. That's a whole nother thing too. Okay.
The line 19 on page 19 talks about the curing situation. Currently, you can cure up until the time the writ of possession is issued. This tightens that cure period up to the answer date, which is under this bill 14 days. And what it says is if you don't pay it within that 14 days to cure, that the defendant tenant loses the right to cure as a matter of law. My understanding is that we often see the tenants able to work with organizations and others to get money to cure. And so that's a policy decision if the legislature wants to tighten it up and remove that possibility after that, whatever the answer period would be. Line on page 20, line 7. This is the court shall set a hearing. Oh, sorry.
I apologize. Let me go back to that. So is this a situation where the court is in the mix on this, or is that really between the parties?
That's between the parties.
Right. Okay. All right. All right. Thanks.
Page 20, line 7. If there's an answer, the court shall set a final hearing not later than 60 days after the service of the complaint, absent good cause shown. This doesn't take into account anything that may have intervened, which I assume would be considered good cause shown. But also keep in mind, there's a right to a jury trial. This would effectively, and this committee is well aware of the 7559A 60-day hold without bail cases that we have to have immediate jury trials on. And so this language essentially is putting this section, these cases on par with that, telling the courts, we want these cases within 60 days. So if they demand a jury trial, that's the goal. And the court would have to, of course, assess whether there's good cause to not meet it. But I suggest that having that in there, knowing right away that it's something that's probably never going to be met for a jury trial within 60 days of the date of the complaint, it might be setting up expectations that are not going to be realized. On page 20, lines 8 through 14 talk about default. There currently is a rule of civil procedure, Rule 55, which clearly sets forth what the requirements are for a default judgment. This sets forth different requirements and does not incorporate all of the Rule 55 requirements. It says that the plaintiff shall file a motion for possession based on the default and shall include an affidavit that provides proof of service. The court shall decide on the motion within 5 days after the filing. Again, the 5 days, you know my position on that. But this doesn't talk about affidavits of military service and majority. It doesn't talk about whether the person is competent under Rule 55 standards. Rule 55 says that you have to have facts to establish liability included in the filing. This actually suggests that the landlord could not follow the law and not be entitled to judgment based upon the pleadings. But because the tenant defendant does not respond, that the court is still obligated to decide the motion and possibly render judgment in favor of the landlord. And so Rule 55 works for a structure to address default. And I'm not sure that trying to come up with different types of structures for that is necessary to effectuate what it looks like the policy is going forward on. Just below that is the show cause hearing. I guess the easiest way to say this is I guess I'm somewhat confused about what this really does. Because the court has to first set a show cause hearing within 10 days after an answer is filed. If the defendant fails to appear, the plaintiff shall be awarded possession of the premises. Let's assume they appear. The defendant shall provide a rebuttal to the facts supporting the termination claims brought by the plaintiff. I don't know what a rebuttal is to the claims. Is standing up and saying, nope, I didn't do it, a rebuttal. It says the parties can rely on an affidavit evidence. So now we know there's an affidavit. Doesn't say the party can rely on hearsay, but that's another issue the courts would have to address. So they rely on an evidence in an affidavit. And if the defendant makes a showing that live testimony is required or upon the court's own determination, a final hearing may be ordered. Conspicuously absent is what kind of ruling the court can make in the case after it hears from both sides. It looks like the only ruling that the court can make if someone appears is that live testimony is required and we have to have a trial. It doesn't provide the court a mechanism to grant judgment if the court thinks the tenant, let's say the court agrees with the landlord, it doesn't have a mechanism to provide judgment. The only mechanism to get judgment in the show cause is if they don't appear. And so I think it leaves you hanging as to what to do. Again, the 21 days to schedule a hearing. I'll use my example of what if there's a jury trial demand? We know that's not happening. We just are not going to be able to schedule that in time.
I think that might be why they took out initially the jury trial demands, but ran into that pesky old constitution.
Due process, yeah. Sure. Tough.
Yeah.
On page 23, this is the process about notices of trespass that is indicated to overrule, that the intent is to overrule a case called State v. Dixon. And on page 23, lines 9 through 14, it says, notwithstanding any other provisions of law, that this essentially, the appeals of this would go to the small claims division, to small claims court. Under 12 BSA 5531, small claims, that the statute talks about small claims, parties may not request claims for relief other than money damages under this chapter. And so it appears that possibly what this is intending to do by that notwithstanding any other provision of law clause is to essentially remove 5531B from applying in these cases and vest the small claims docket with these particular cases. If that's the intent of the legislature, I would suggest that you might want to be a lot clearer than just notwithstanding any other provision of law, because this is not just about saying we're going to do something different. The question would be, Is that enough to actually vest authority in 5531B? It may well be, but I can't opine on the eventual legal determinations of whether it is or isn't. But it's very clear that those two butt up against each other because of the limits of small claims. And small claims is just not something we have seen. First of all, a court of appellate. We don't have rules set up for any type of appellate procedures in small claims court. So that would require rulemaking to set up procedures under this.
Ian?
Hey, Judge, thank you. I guess my question would be, could this just go to the civil division in an expedited way to allow for the appeal right? I think the hope was to try to find some court that could take this type of appeal quickly, which is why small claims was suggested. And that was kind of the intent, was to expand the jurisdiction to be able to have this appellate right. I guess it could be obviously very much clearer. So I'm just curious do you think, could that appeal right just be given to the civil court, or do you have another suggestion for a place that an appeal of a no trespass order issued to an invitee could go?
The options are civil division, judicial bureau, in the nature of municipal type matter, something like that.
Yeah.
The judicial bureau is when you add statutes and say we're going to now handle them. Following closely along is a jurisdictional statute that says judicial bureau has jurisdiction over, and the legislature adds those too. So you could put it there.
Judicial bureau is interesting.
Yeah, that makes sense.
Okay, thank you.
And then the Judicial Bureau would have to also establish procedures, but wherever it goes, there's going to have to be established rules to address how do we handle these cases.
Yeah.
On page 25, this starts talking about confidentiality. Now, Terry Corsones is going to talk about this in a moment, but just a couple quick points on this. The section 4873, lines 10 through 16. This talks about the records being confidential, and at the end it says, unless the court orders continued confidentiality. Don't have any standards for what we would look at to determine whether or not we're going to issue continued confidentiality. What is the intent of the legislature? What would be the basis that the legislature would want the judges to continue confidentiality or to not? And so that's left unclear. On line 18, I would note, I think the Legislative Council did mention this, that it was something that a person who was asked about the ejectment history may answer there's no prior ejectment. That's only apparently applies to the tenant who can say that. Certainly landlords can, but there's nothing here that binds a landlord, and a landlord can talk about it freely and openly. And on page 27, lines 1 through 3, for access, in addition to access provided for these records, the court can available to any person with a valid court order authorizing access to the ejectment record. I assume that means that if there's an order from another court, because there would be no mechanism in our court necessarily to open it up because there's no standards as to whether someone can get it. I could see it perhaps in some type of unrelated case where a party to the action and it becomes part of a discovery dispute where someone wants it and tries to get it. They could issue an order, but again, there's no standards to guide the court as to, for our courts, as to when to open it up. So that's about all I have.
Well, that won't take much to next.
Maybe after the.
So, thank you, Judge. I'm
you very
sure
much.
that we'll have another round before, as we continue to look at this. We can have, Terry, if you have about like pretty short, or we can reschedule, or we can do both if you want, because we need to.
Best for you, I don't mind coming back, because I was gonna address confidentiality in scheduling repercussions from what's in here, but.
And then everything works out fine.
Yeah,
it's like good to go. If you're gonna fully support this.
It's taken a little longer than that to,
Oh,
there were issues and concerns.
You have to leave, right?
Yeah, I do. I'm sorry.
So I'm happy to
Yeah,
come back.
I'm about to lose my quorum.
I wish I could.
Which is fine, so we'll schedule you when we get back along with other witnesses as well. So. All right, so, I wish I could have caught everybody before you left, because
I know, it's like,
we're gonna be
more cookies for us.
adjourned until 9 o'clock on Tuesday morning when we get back. And I'll make sure I, get that message out to everybody that we usually don't, adjourn till 1 o'clock on Tuesdays, but we will adjourn until 9 o'clock, this. So